Your claim today, Graham, is for how much?
£4,300.
There's also damage to your property, including a carpet, correct?
Yes, Judge.
That was not included in your initial claim.
No, Judge.
Would you like to amend your claim now?
If I could, yes.
But that's not the end of the matter, because in addition to responding that this is not entirely your fault, because you have a third party who's effectively taken the money, so you could not complete the work.
Yes.
That's part of your legal response. As I understand it, you also have a counterclaim against Graham. What is the value of that claim?
Just over £2,000, I think.
£2,515. Now, this is what you say you're entitled to for your labour, correct?
Correct.
What would you like to say in response?
That seems a very exaggerated figure, Judge. Bearing in mind the standard of work and the actual cost it's going to cost me to repair the damage that's been created. To be perfectly honest, I gave, even taking away the kitchen, there isn't £2,300 worth of materials in that garden.
Graham, I have to tell you, you are lucky in this case in some ways. You entered into a legal arrangement with Luke where he was going to do work in your house. Now, I accept he's a gardener and doesn't do kitchens. I suspect that there was confusion at best, something else at worst, between him and that third party. And so, consequently, he couldn't complete the work. That, sir, is not your problem in law, because your contract was with Luke as you understood it.
Yes, Judge.
Now, the difficulty is that that also wouldn't be enough in this case, because I have to say it was rather stupid of you not to get everything in writing.
Yes, Judge, I know
It was further unfortunate for you to give such a large lump sum of the work before the building had started. And if you bought this claim purely in contract, I would have difficulty with it. However, you don't just say this is a breach of contract, you say much more importantly that the work has not been completed to reasonable value or of a reasonable standard. I have compelling evidence that that is clearly the case. As a consequence, you are entirely entitled to the full sum of anything you have paid back. And so I have no difficulty in awarding you anything you've paid to Luke over there, which is £4,300, and that should be the end of the matter. However, in the course of the proceedings, it's emerged that you've sought to amend your claim because, rather sadly, you simply forgot that there was other damage caused to your property as a result of the negligent work. You claim the carpet was £200 when you first put it in. I think it's going to cost you considerably more, at least another 100, so I add an additional 300 to your claim. The full value, therefore, I can award you is £4,600, and that's the award of this court. Now, Luke, you are the person responsible. That's especially the case because there's nothing in writing.
Yes.
What I will say is this. If you feel hard done or cheated, there's a lesson in this. Not just to get everything in writing, but if your story is correct, and I suspect, I don't know, it may be, then you need to proceed against Carl. The award of this court is £4,600.
Graham won his case and was awarded £4,600. Defendant Luke's counterclaim was dismissed. Let's find out how both parties felt about their day in court.
I understand Luke's predicament, and I get Luke loads of opportunities to carry out the work. And I do understand and appreciate him actually turning up here today and having the gumption to turn up. I've no hard feelings towards Luke. It's just things have happened, and that's where we are. And I just want, you know, people are out there who do like his partner that do that, and people should know they're there.
If I was going to do any work in the future, it would be just landscaping. I wouldn't trust anyone else to go and quote up any other jobs because look where it's got me. It's just not worked out well at all.
No, we are where we are.
And I do apologise for it. And
I accept that apology. Thank you. No problem. Well, everything will be in writing with both copies, one of each, signed, sealed and done. I'm not going down the verbal agreement route ever again.
Cheers.
Cheers, mate.
For more Judge Rinder cases, click here. And if you've got a legal issue of your own, get in touch with us by clicking over here.